rise, please. The Court of the State of Washington in for Skagit County is now in session. The Honorable William Steffener, Judge, is presiding.
Please have a seat. Thank you. Good afternoon, everyone. Sorry, I'm short, so just moving this chair up. Okay. That'll be. Okay, and so we are here this afternoon, and today is Thursday, November 16th, 2023, and we are here on the matter of, in the matter of the recall of Richard A., and I apologize if I mispronounce any names here, Richard A. Wayrich, Skagit County Prosecuting Attorney, Sandra F. Perkins, Skagit County Auditor, and Donald L. McDermott, Skagit County Sheriff. This is a hearing following the filing of the petition to recall each of those county officials, and the petition was prepared and filed by the Attorney General's Office following the filing of the statement of charges filed by Skagit County resident Cody Hart. If the parties could please introduce themselves for the record.
Eric Peterson from the Skagit County Prosecutor's Office representing Richard Wyrick, the elected prosecutor, and Donald McDermott, the elected Skagit County Sheriff.
Thank you. Welcome.
Cody Hart, the complainant.
Okay, thank you.
Your Honor, I'm Craig Kamek of Skagit Law Group, and I represent the elected auditor, Sandra Perkins.
Okay, thank you very much.
And good afternoon, Your Honor. I'm Carl Smith. I'm here in my role as the preparer of the ballot synopsis.
All right, thank you so very much. Welcome, everyone. And so we have a number of pleadings that were filed here. And so there's the petition, as well as the memorandum that was filed by the Attorney General's Office, and Exhibit A of that is the charges that were filed by Mr. Hart. Then there's the memorandum in response that was filed on behalf of the Sheriff, Sheriff McDermott, as well as the declaration by Sheriff McDermott, a memorandum in response that was filed by the counsel for the prosecutor, Mr. Wayrich, as well as his declaration and a declaration of his counsel, Eric Pedersen. Is it Pedersen or Peterson?
What was the question?
Your last name? Is it Pedersen or Peterson?
Mr. Wyrick?
No, counsel Eric? Peterson.
Sorry.
I just wanted to make sure that I was pronouncing it correctly. Peterson. And then there's the memorandum in response filed by counsel for the auditor, as well as the declaration of the auditor as well. I also received a proposed order from Mr. Hart. And it appears that there's some preliminary issues that we need to address first. There's two motions, one to disqualify Carl Smith, the Attorney General's, from the Attorney General's Office, and then there's a motion to disqualify Mr. Peterson. And so with regards to the first one, the motion to disqualify Carl Smith, I received and reviewed the motion, the memorandum in support, as well as a response to the motion to disqualify that was filed by the Attorney General's Office, the declaration of Carl Smith in support of the response, then also a response to the motion to disqualify the Attorney General's Office that was filed by the Skagit County prosecutor, and also a declaration filed by Mr. Hart in support of the motion to disqualify, as well as a proposed order from Mr. Hart. And so, Mr. Hart, the motion is yours, and so you have the floor.
Yes, Judge. The brief pretty well outlines it. I don't want to repeat it verbatim, but I'll hit on the high points. Carl Smith, as the Solicitor General, has a role in his capacity to serve on behalf of the Attorney General to prepare the ballot synopsis for the prosecuting attorney. The RCW are referenced, as well as the constitutional provisions for that. Where the problem comes in is Carl Smith also decided to take what I consider the illegal role, frankly, of contracting then with the person that he's preparing the ballot synopsis for.
Can you please turn your phone off? Go ahead, sir.
Yeah, so I'll just point out that the legislative intent of having the Attorney General's office prepare a prosecuting attorney's ballot synopsis to eliminate that conflict of interest that could be occurring. That's obviously one of the motives behind it. The legislature did not plan on the prosecuting attorney hiring someone to prepare a ballot synopsis who would then be preparing their own in the same recall election. Again, my brief is very detailed, but that's the basic foundation behind all of it. I also would point out that I was surprised the Attorney General's office, because I believe is a point of contention. As I stated, Carl Smith is named as a participant in the recall charges. That evidence was submitted in the recall petition. Before this whole thing started, they had an opportunity not to involve Carl Smith right then. And they shouldn't have, and I think this court should agree with that. The Attorney General is the one required to prepare the ballot synopsis, not Carl Smith. There is no obligation for him specifically to do it, and him stepping into this role, frankly, it's absurd, and it's unjust to me. This is a recall I am petitioning for, and this process has rules in place to protect this kind of stuff. And so I'm asking the court and you as the judge to enforce the laws on this and disqualify him in his capacity as preparer of the ballot synopsis. And take whatever action additional to that you find appropriate. Because again, the Attorney General is a lawyer, Carl Smith is a lawyer. I'm not a lawyer, but I know what the law is on this. I read it, I gave it to the court. The court knows the law on this after I pointed it out. I don't expect everyone to have a perfect memory. But this appears to be just a gross misjudgment. There may be more to it, but at the very least, it's a gross misjudgment, and it's preventing me my rights to have a fair process proceed.
Okay, thank you. And so, Mr. Smith, I will, you filed a response. I will hear from you next.
Thank you, Your Honor. I think I would like to largely stand on the brief that we submitted to the court. I would just like to briefly respond that an additional point occurred to me this morning, which is if this court were to grant the relief that Mr. Hart seeks and strike all the pleadings, then there's no petition before this court and there's no hearing possible today. So that's just kind of an additional practical problem with the relief he's seeking. But more fundamentally, for the reasons laid out in our brief, there is no conflict. As this court can see in the statement of charges, there is no allegation of wrongdoing on my part or the part of the Attorney General. It is an informational email that was provided that did not take a position on any of these issues. So Mr. Hart has not identified a violation of the rules of professional conduct. He has not identified a statutory violation for the reasons laid out. And more fundamentally, I have no role, no further role today, Your Honor, unless this court seeks assistance. We submitted a ballot synopsis, which this court is free to correct, and this court should correct if it identifies any inadequacies with that ballot synopsis. So with that, we would ask this court to deny the motion and specifically to deny it on both alternative grounds that it was untimely and on the merits. Thank you.
Judge, I do have to object. He mischaracterized and frankly stated a falsehood in his response. I did lay out the statutory...
Okay, sir. But the way the court hearing goes is we hear from each of the parties. You are the one that filed the motion, so you are going to have an opportunity to speak again. But I'm first going to finish hearing from him.
Okay.
Once he's done, I'm going to hear from the Skagit County prosecutor because they filed a response as well. And then once they're done giving their response, then you have the floor again, okay? So was there anything else, Mr. Smith, that you wish to relay?
No, Your Honor. Thank you.
Okay, thank you. And so, counsel, you have the floor.
Yes, Your Honor. Thank you. May it please the court, Eric Peterson on behalf of the Skagit County prosecutor, Richard Wyrick, and elected Sheriff Donald McDermott. Mr. Hart's characterization of Mr. Smith's involvement in that prior one memo that occurred, I think misrepresents what his role was in handling that one situation. He has, as the Attorney General, the obligation by statute to actually prepare the ballot synopsis involving the prosecuting attorney. So that role cannot be taken to someone else, and the basis he provided for a claim of conflict for Mr. Smith that just is not present. Now, we designated and provided a special deputy appointment for Mr. Smith, the Deputy Solicitor General, to file the ballot synopsis for the other two public officials which were the subject of his petition. The reason makes logical sense. You're already doing the one for Mr. Wyrick. He's in a position review. He's already doing that. The other two, since he's making a claim against Mr. Wyrick, as far as improprieties, he would raise a claim automatically against the prosecutor, who would then be making the determinations as to the ballot synopsis for both Mr. Wyrick and the sheriff. So his role in that as a special deputy was appropriate. We filed and provided the court the full oath and appointment, which shows that Mr. Smith's obligation was limited to just doing the ballot synopsis in this scenario. So his role was appropriate, and the aspersion cast by Mr. Hart should be rejected by this court, and the court should deny the motion to disqualify. Thank you.
Okay, thank you. And so now, Mr. Hart.
So, Judge, as I said, Mr. Smith mischaracterized my statements. He doesn't have that authority. I did lay out the statutes and the provisions that were violated. I'll also point out that the link in connection with the overall recall basis with the Attorney General's office is laid out. It is in front of you for that subject matter. I'll also point out, in response to the lack of acknowledging the flaws in the appointment of Mr. Smith, that the court was notified and the public records and evidence submitted to the court showed there is no appointment for Mr. Smith in any legal capacity as a special deputy prosecuting attorney. I don't think anyone is fooled by the fact it doesn't say special deputy prosecuting attorney. It's not for Skagit County, and it doesn't state he has an oath to the United States of America. These are three critical flaws in his oath that he claims as special deputy prosecuting attorney, and there's no court in this state that will accept that. I'm asking you to simply do what every other judge and court in the state will do, is say that is not a valid oath, that is not a valid appointment as special deputy prosecuting attorney, and it has no legal standing. And as such, everything he has done in that capacity has been without legal authority. I can claim a lot of things, and the court would admonish me, it would sanction me. It would do so, and it's done so to many pro se, pro per defendants and plaintiffs. These attorneys are committing acts of misconduct in front of the court. They are submitting documents without legal authority. Of all the members of this government, the judicial branch and lawyers know better. And for the court to allow it to happen, frankly, you're telling me and the pro se, pro per plaintiffs and defendants in this state that you have to follow the law to the T. We do not. That is not a standard this court should set, and I don't agree with it one bit. With that said, my positions in the brief are very laid out. It is very clear that my motion to judge that Mr. Smith's appointment was not lawful is supported by the evidence in my claims. My motion to void his appointment or judge that his appointment is void as a matter of law is substantiated by the evidence and arguments in front of you. And nothing he has done has been lawful in this court in those capacities, and this court can't stand for that. If this court wants to behave that way and this move forward, it's anarchy. It's a disrespect to the law, and I just ask the law be followed and there not be a bunch of exceptions because you guys are lawyers, and make people who aren't lawyers follow the law.
Okay, thank you. Well, this court has reviewed all of the pleadings from both sides, and after review of the pleadings as well as listening to oral argument, this court does not agree with the position of Mr. Hart. The appointment of Mr. Smith, I don't see a factual basis for his disqualification nor any merit to there being a conflict in this particular instance. I've reviewed all of the pleadings and the statement of charges that was filed by Mr. Hart, and I don't see how there's a conflict based upon the information that's been provided to the court at this time. So I will deny that motion to disqualify Mr. Smith. Not to mention that there is the procedural issue that if the court were in order to disqualify Mr. Smith and reject all of his pleadings, there would be no basis for having this hearing here today, and the petition would be null and void at that point in time. Yes, sir.
May I speak, Judge?
You may.
To that matter, I've heard that be an argument to this. If what you're saying is because of the inconvenience of what has been committed, then that is a consideration.
That's actually not what I'm saying, sir. That's not a consideration. That is simply dicta. That's not the basis for why I'm ruling the way I'm ruling. It's based upon the pleadings that you filed and the information that's contained within there. And I just don't see any factual basis for the disqualification of Mr. Smith in this instance. His appointment is logical in this instance, given the fact that he is required by statute to be appointed to deal with the petition for the sheriff in this instance. And given that and his familiarity with the charges that you have filed, it simply makes sense for him in order to address the conflict that would be present if the prosecutor were to handle the other matters. And so it does make sense. It is logical, and the court is denying it based on the other reasons, not that that was simply dicta for the court's decision.
Can I ask one last question on this subject before we move on?
Certainly.
And the mechanics of the flaws of his oath not complying with statute, him not having an oath to the United States Constitution, is that a concern for this court?
Are you basing it upon the typo where it left off the S of the United States?
That is a significant element.
That is a typo, sir. It's a Scribner's error. So that is not a significant element. And so that creates no basis for disqualification in this particular instance. The oath is valid.
And the oath being for Thurston County, is that appropriate for a Skagit County position? I just want to make sure you're aware of the technical flaws of what it is. Again, Judge, there is no oath as the Skagit County Special Deputy Prosecutor or to Skagit County in any capacity in that. He is serving Thurston County in this court.
And on that point, counsel?
That's actually the location of the declaration, not necessarily. Is that the version you provided me, Mr.?
There's no document with his appointment to a Skagit
Sir.
County. Okay.
It appears to be, this was a declaration signed by Mr. Smith, who resides and works in Thurston County.
Oh, Mr. Smith is residing in Thurston County?
He's nodding his head, yes. He's an attorney general working out of Thurston County.
Ah, okay.
Your Honor, may I be heard briefly?
Yes, you may.
I just wanted to reiterate that the term Thurston County that appears in that oath of office indicates that it was signed in Thurston County. It also has Grace Harbor County on there because that is where the notary public resides, and it says residing in Grace Harbor County. And above that, it says Thurston County because that is where the notary public was present when that oath was signed. And finally, you'll see in the text of that oath of office, it is to perform the duties of the office of the Special Deputy Prosecuting Attorney as authorized by this appointment. And the appointment to which it is attached clearly says Skagit County.
I'm reviewing that at this time, yes. Counsel, thank you very much. You had something else to say, sir?
I would just point out the contractual flaw in a document that does not link the documents. Those documents can, if you accept this process for future contract debates, you can allow anyone to insert any page without any connection within the document. And that is just a fundamental gross misapplication of contract law. Appointments work the same way. Every other appointment in this county indicates the signatory and the appointee on the same sheet and the position. And there are other ways, but the reason that's done is to create a connection between the two. I'm not convinced he has an appointment. I've challenged it. I'll let you judge on it. I've tried to point out the technical flaws in it.
And sir, it actually does reference the Special Deputy Prosecuting Attorney here. It impartially performed the duties of the Office of Special Deputy Prosecuting Attorney as authorized by this appointment. It's attached and filed as 2 pages with a copy of the case-specific appointment of special duty and oath of office that's also signed by the prosecuting attorney. So it is valid.
That's not the document that's filed with the county. If you're stating that the documents are connected through verbiage in the document, that is not the document that was filed with the auditor's office.
It specifically says that it's filed with the Skagit County Auditor's Office. It was filed on 10/26/2023 at 8:47 a.m.
Is the page with the signature of Mr. Smith have any connection to any other page in that?
The Special Deputy Prosecuting Attorney, as it's referenced within
That is not what was originally filed in this. What is the date on that document, Judge?
October 19th, 2023.
Okay. I'll bring this up after this hearing, Judge, with what I have on the record as being received.
No, you filed the evidence for the hearing today. We're having the hearing right now. The court is making its ruling as of right now.
I understand. I'm concerned that you're seeing something that was not originally submitted. That's what I am concerned about.
Okay, well, unless you have evidence of that here and now.
It was submitted
then
as a request for judicial
When I'm talking,
notice.
sir,
Sorry.
and the court is ruling, then you stop talking, okay? That's how this works. Now, in addressing your point, unless you have evidence suggesting that this is a falsified document, which I have no reason in order to believe that it is at this time, then the issue is done. Do you have something there that you would like me to see?
Yes. Okay, Bailiff,
Yes?
I wish you to confirm that this is the document you're referencing right now.
Yes, it is.
And does the term Skagit County appear on that document?
It does not, nor does
Okay,
it need to.
that is my point. It is a Thurston County Deputy Prosecutor Attorney appointment.
Okay, your point is noted, and the motion is denied. And so I am signing the order on motion to disqualify Carl D. Smith. Actually, before I sign this, Mr. Peterson, do you have a signed copy of this?
I have an original version here, Your
Perfect.
Honor. Does Mr. Hart wish to sign? He's declining the shipping.
Thank you, and I'm drawing a signature line on here. I'm putting Cody Hart's name underneath it, and above it I am indicating decline to sign.
Your Honor, given that the role of the Attorney General was just for preparation of the ballot synopsis and actually would have no role in reviewing the sufficiency of the charges, or for that matter, altering the language that's proposed, unless Mr. Smith believes differently, Deputy Solicitor Smith believes differently, I believe he can be released from this hearing.
I have no reason to believe that Mr. Smith is required in order to be here any further. He's already completed his role. Mr. Hart, did you have something to say on that matter?
I did. I just wanted to confirm we have a couple items ahead of this. We have a motion for amending the ballot synopsis, and we have
That would come last.
no. The point being, Judge, is Mr. Smith going to be if either party prevails, will there be an order given to him that he would need to be present for or to discuss the order?
He would not. He's already prepared them, and so the question would be whether or not we need to amend them as written at this point in time. And he doesn't have any role in advocating one way or the other with regards to that. So
That answers my question.
he can. No offense to Mr. Smith, but he can advocate all he wants for the ones that he's written or for either side's amendments, but the court would not be taking his position into consideration because that's not part of his role.
And then I would actually request, Mr. Smith is being challenged on his statements in the ballot synopsis. The role of the preparer of the ballot synopsis is to evaluate the claims and prepare a synopsis for claims that would warrant removal from office. Mr. Smith is the writer of this document. He has, on behalf of the Attorney General's office, prepared these documents and the ballot synopsis with the instructions and with the instructions to prepare the ballot synopsis for that purpose. I do oppose him leaving the proceedings. There will be dispute over what the purpose of and the validity of each of the statements are. I have my own because I don't think they're adequate. The opposing party has their own because they wish to remove them. The Attorney General needs to represent why they put them into the ballot synopsis and as required as items to be indicated as justification for removal from office.
Fair enough. Mr. Smith, if you could please stay with us, and we'll see whether or not any further testimony from you is necessary. But if you could stay online, that would be fantastic.
Yes, Your Honor.
Thank you. Okay, so that addresses that matter. The second preliminary matter, and that needs to be addressed, is the motion that was filed to disqualify Eric Peterson as counsel. And then once we finish with that one, we'll move on to the issue of the well, what we're here for today, the petition itself. And so the motion to disqualify Eric Peterson was filed by you, Mr. Hart.
Thank you, Judge.
You have the floor.
Yes, Judge. So there is a long history of Mr. Peterson acting in this capacity as a public official to using public funds and public resources to defend the right of Skagit County officials to hold office. It's happened on multiple occasions in local district court, superior court, and in federal court. I am perplexed at why this issue is not being judged upon. I'm asking the court to judge upon the issue, whether the Constitution of the state of Washington, whether the statutes, the RCWs mentioned in the brief and the memorandum, allow Mr. Peterson to defend the right to hold office of those being petitioned for recall, Wyrich, Perkins, and McDermott. I have provided the court a very detailed memorandum on the specific RCWs and of the ethical violations involved. I have a motion in front of the court to disqualify him and strike his submittals into the court record as unlawful, and that is in front of the court right now.
Okay, thank you. And I should have said this to begin with, but what the court received on this particular issue was I received the motion to disqualify. I received the memorandum in response to the notice of appearance of Eric Peterson, both filed by Mr. Hart. I also received a proposed order from Mr. Hart, as well as a response from the Skagit County Prosecutor's Office, and I believe I also have a proposed order from the Skagit County Prosecuting Attorney's Office as well. And so, if I've missed a pleading, please let me know.
Judge, please. Those were filed earlier today. I did file a court copy, but just in case they've been overlooked, and I apologize for stapling them, but I do have in there a motion to disqualify. You were previously provided a brief in response to the notice of appearance. That is the key document. I would ask the court to recognize, and then you have a proposed order in relation to Mr.
To recognize what? What is it you're asking?
I just want to make sure you have the brief in response to the notice of appearance of Mr. Peterson.
That's what I just indicated that I had, the memorandum in response to notice of appearance of Eric Peterson that you filed?
Okay, I did not hear that. My
Oh,
apologies.
okay.
Yep. And then you have the motion, and that's what in front of you.
Yes, as well as the response regarding the appearance by counsel. And I did receive the request for judicial notice. I received 2 documents entitled Request for Judicial Notice. And so, but as I indicated on the record, I'll keep it. Did you need this back, sir?
No.
And as I indicated on the record, I received those documents and have reviewed them. And so, since you have stated your position, sir, Mr. Peterson?
Your Honor, briefly, I just should note that Mr. Hart was not aware, apparently, of the Commissioner's resolution, which I've filed with request for judicial notice number 2 and Exhibit 2, showing there was actually an appointment, which is actually specifically allowed pursuant to RCW 4996-041, subsection 3. Mr. Hart cited subsection 1 of that section. Subsection 3 specifically pertains to recall petitions and authorizes the appointment of and representation of public officials at county expense in just this type of scenario. Provide a couple quotes on the citations of case law that support that being appropriate. There was a resolution signed by the commissioners, approved by the project attorney after the request of the public officials for representations. Entirely appropriate, and the motion to disqualify me from participating in this, which is nearly identical to every action in which I get involved in with Mr. Hart. He seeks to disqualify me on basis which lack true legal support. And so the motion should be denied.
Okay, thank you. Mr. Hart?
I don't believe there is an exemption to the recall for acts of neglect of duty. Let me get the wording out correctly here. Official misconduct. That can't override the constitutional provision. And I don't know why you can't override the Constitution with RCW, otherwise it would have changed the Constitution. I gave you the reference to the Constitution in there. It's misapplication of it to say in the claims made against these defendants that he has legal authority.
Okay, so pretty much every single county has a civil prosecutor's office, and their job, having formerly been a civil prosecutor at one point in time in my career, one of their jobs is in order to represent other county officials and county departments. That is a statutory duty, and in this particular instance, RCW 4.96.041, subsection 3 specifically addresses this particular scenario. And it permits representation at the county expense of elective officers in recall matters. And so this is a lawful representation in this particular instance, and there does not seem to be a factual basis for disqualification. Again,
I stand on my, that it's being applied incorrectly. The claims of official misconduct and neglect of duty do not fall within that exception. That is a sliver of the exception. Otherwise, again, the Constitution would have been changed. And so applying it to the claims made in this case are inappropriate.
This court disagrees with your analysis in this particular instance, sir. And so at this time, the motion to disqualify Eric Peterson as counsel for the reasons and bases provided within the briefing and within oral argument is denied.
Does Mr. Hart wish to sign the order on that matter?
And if you have a signed copy of this order, that would be fantastic.
And for the record, Your Honor, I have provided Mr. Hart copies of these proposed orders previously.
Thank you, counsel. And there's a signature line here that's been handwritten in with Cody Hart's name listed underneath it, and I am simply writing above the line, decline to sign. Okay, that order has been signed. Okay, and so we are now to the petition for which we are here for this hearing. And so this hearing is, as indicated at the outset, is brought on after filing of the petition to recall the Skagit County Auditor, Sandra Perkins, the Skagit County Prosecutor, Richard Wayrich, Skagit County Sheriff, Donald McDermott. And also, as previously indicated, the petition was prepared and filed by the Attorney General's Office following the filing of a statement of charges filed by Skagit County resident Cody Hart. And I'm going to just go through a couple of things here and then give the parties the opportunity in order to provide oral argument. And so based on the court's review of the briefings provided, as well as a review of, in the matter of recall of Washam, spelled W-A-S-H-A-M, a citation of 171 Washington 2nd, 503 from 2011. It appears that recall of an elected official can only be made for cause. The court is to determine at the hearing two questions. The threshold question is whether the charge or charges are both factually sufficient and legally sufficient. And then once that is determined, and if there is a charge or charges that is deemed to be sufficient, then the court is to determine whether or not the ballot synopsis that's been prepared is adequate, or whether or not there needs to be any amendments to it. And if the charges are found to not be sufficient, the recall may not proceed at that point. To determine that a charge is factually sufficient, the petitioner is required to show that, one, the official intended to commit the act, and two, that the official intended to act unlawfully. To determine legal sufficiency, based on the case law, charges must specifically allege substantial conduct amounting to misfeasance, malfeasance, or violation of the oath of office. Officials cannot be recalled for their discretionary acts absent a manifest abuse of discretion. And further evidence must show that the public official intended to commit an unlawful act. And so with that being the understanding of the courts, Mr. Hart, you have the floor. It is your charges, and so is there anything else that you would like to have the court know before the court rules?
Yes, Judge. So I do have, I guess this is the time to bring everything up. I did submit a brief in support of amended complaint because of my opposition that the ballot synopsis had inadequacies in it.
And that would be the next issue after first dealing with the sufficiency of the charges.
Okay. I'm afraid I must have misunderstood. So my apologies, Judge. So the sufficiency of the charges, what is the question that's being asked of me right now then?
Whether or not you have anything else that you would like to address with the court with relates to the written charges that you've submitted at this point in time, on whether or not you find the court should find a factual sufficiency for the charge based on the case law, or whether or not there's a legal sufficiency for the charge based upon the case law. You received the briefing from the other parties as well?
Yeah, I provided a brief, and that's what I was. It's maybe, and I hope I'm not trying to do what I just did, but I thought that's what you'd said. I'd written a brief point by point to the charges. Yes. And I was going to go through that.
And that's fine.
Okay.
This is the opportunity in order to do that. With regards to the motion, you're talking about the brief, though, with regards to the amending the synopses as they are currently written. Is that correct?
Yes.
But before we get to dealing whether or not they are adequately written, we have to deal with whether or not what you have written in the charges or what came in Appendix A of the petition, whether or not there is sufficient evidence to support the charges that you've put against them, which form the bases for each of those synopses.
Right. Yeah, I'll make a statement with expectation. We'll get into this in a minute. Okay. As far as the sufficiency of the charges, Judge, the court was provided about a 165-page document that was summarized into the 200 words in front of you. Yes. And so the Attorney General's office had broken down in what they identified as 7 violations that they were noting as justification to remove the Skagit County officials from office. In reality, they ran out of room. That's a fact that I'm going to make sure the court just gets my opinion on that. There are more charges, but they don't have enough room to be in there. There are probably, if you were to number them the way that the Attorney General's office did them, they're probably close to 20. So if these are not sufficient enough, the charges that were in the original recall petition, I am not going to say the Attorney General, who I've told you should not have done this, if we remove any of them, then I would motion that we get them replaced with ones that are deemed sufficient, that have been submitted to this process already. With that said, there are 165 pages that include public records. They include certified documents that substantiate the charges. And I believe the allegations include very sufficient reference to statute and constitutional violations, most notably violations of duty that are outlined in the legislative instructions to each of those being recalled, is what their duty was that they violated, that they neglected to do. So I do believe there's more than adequate sufficiency, but I also make sure to emphasize there are 20 charges. Only 7 of them made it into this.
Okay. And which counsel would like to go first?
Your Honor, we've attempted as best we can to detail a response to what are at best nebulous documents claiming charges, 7 charges against the auditor, but 7 charges against the prosecutor and 5 against the sheriff, many of which are based on Mr. Hart's misinterpretation of the law and misapplication of facts. I would be glad to go through any of the individual charges in describing why the complaint he drafted is deficient, but I think it'd be wasting my court's time until the court has sufficient facts showing anything from any of the particular 7 allegations against the sheriff, or 5 against the 7 against the prosecutor, or 5 against the sheriff. He comes here stating nothing different than is contained essentially in the pleadings he's filed with the court. Those things were extremely difficult for the Attorney General to even draw charges from, because there's no specific dates of
Objection.
conduct of the individual fish.
You'll have an opportunity to speak, sir.
There's no specific dates of conduct of any of the elected officials identified. It's based on, to a large extent, hearsay, and we do not agree with judicial notice for numerous documents contained within his declaration, which cites things like a transcript of a conversation he had with a deputy of the sheriff's office, and a recitation of a conversation he had with a deputy auditor. Those things are not subject to judicial notice. They're not public documents that can be obtained and identified. They're not part of a court finding or order. Mr. Hart is attempting to basically draw these things he's tried to spread at other courts to try to change this to a recall petition. But to do a recall petition, even though it's different from the other type of actions, he has to identify things in concise statements that identify what these public officials did wrong. We are at extreme deficit in even trying to respond to this recall petition, because he does not identify acts of officials on particular dates. He relies on statements of not the elected officials, but their deputies. Those are insufficient to say this official didn't do this on this particular day, and here's the law requires him to do that. So unless Mr. Hart can identify any of those particular in the 7 charges he has against the prosecutor, or 5 against the sheriff, I think it's a waste of our time for me to try to explain why they're all adequate at the start, when he has the burden of proof at the start to show that they're both factually and legally sufficient.
Okay. Thank you, counsel. Sir, you'll have your opportunity. Let other counsel have his opportunity.
Thank you, Your Honor. And again, Craig Kamek for Auditor Perkins. I concur with the statements made by Mr. Peterson. It is Mr. Hart's burden to prove a prima facie case. He has not done so. I mean, for the petition of a single individual to overrule the will of the electorate of Skagit County is a no small thing. And therefore, the law sets standards accurately explained by the court at the opening of this part of the hearing. And frankly, what I don't want to do is go through, waste the court's time, as mentioned by Mr. Peterson, reiterating what we've already briefed adequately, that he has not met the standards for either factual sufficiency or legal sufficiency. He has thrown a bunch of items at the wall, some transcripts of conversations, number of statutes, and thrown them up into the air, and he'll hope that the AG or the court assembles those into some sort of logical basis by which he can meet his burden. It's his burden, and he needs to do it. And frankly, I don't want to go through line by line, unless requested by the court. I'm happy to. I don't want to train him on where his errors are. They are not legally sufficient. They're not factually sufficient. None of them have the dates, the specific acts of conduct, immeasurable legal standard, immeasurable legal violation, any personal basis of knowledge for the facts alleged. None of them even come close to a prima facie case. So they're all inadequate, they're all insufficient, and they should all be denied.
Okay, thank you. Mr. Hart?
First, and I apologize before for the objection being out of place.
No,
I thought it was.
It's fine. In this particular instance, an objection, this is argument, and so counsel and pro se litigants are given a wide latitude in order to make their arguments, and then, like in this instance, you are the proponent in this motion, and so you get the last word.
So what I was speaking to there is the inappropriateness of Mr. Peterson speaking on behalf of the Attorney General's office. He was speaking first person for Mr. Smith. That is not something that's appropriate, and I wish that to be, he's not allowed to do that. Mr. Smith can speak for himself. Second, I heard both defense counsels here. It flabbergasts my brain to think that they don't think that there's adequate information. My understanding, Judge, is that this court is not, and this hearing is not to try the facts, but the sufficiency of the charges. I believe, and if I'm miswording it precisely, I don't have the RCW in front of me. If we want to go to a litigation for civil or criminal charges, if that's what they want to do, then they're in the wrong court. It's not this court. This is a recall. This is a citizen-driven recall. And it's astounding that a lawyer would say that citizens don't have a right to petition for a recall. That is what I just heard. They just told the court, citizens don't have the right to recall. One person doesn't have the right. This is not the recall in here. It goes to an election. You're trying to stop the process. You're trying to stop the people from seeing what the charges are. Again, there are more charges than could be written down here. And I will go back to the process that I understand this should be. If we want this to be a criminal or civil case, and go through the evidentiary rules and the testimony, I'll be happy to turn it into that. But that is not what this is. If you want me to subpoena people and have the court subpoena...
Sir, we don't need to reference or threaten what other litigation we can do. Just
no, that's not...
Focus on the facts.
Yeah, that was not my intent. So with that said, I understand this process is to move forward today to go through the specific points of the Attorney General's determination of what would be recallable offenses. I want everyone to remember that. Sorry, Judge, I don't mean to speak that way, but there are more than can ever be listed here. They picked these. There's others. But this is the Attorney General's office stating as a lawyer that these offenses would justify the recall.
Okay. Thank you. Okay, and so I spent all day yesterday, as well as my morning, going through the various pleadings that continue to keep flowing in over the course of the day yesterday and this morning. And in particular, when reviewing for the purposes of the sufficiency of the charges, I was reviewing in concert with each other, not just the synopsis that is written by the Attorney General's office in this instance, but also Appendix A, which was the charging document that you, Mr. Hart, filed. And so when going through all of this, I was not simply relying just on the synopses as stated in Exhibits G, H, and I with regards to the ballot synopses of recall charge for the prosecuting attorney, the auditor, and the sheriff. But going through the actual evidence that you provided to determine whether or not there was sufficient evidence. So, starting with the auditor in relations to Skagit County Auditor Perkins. Was Perkins, right?
Correct.
Okay. So synopsis number 1, there's 7 synopses here. The first one is in relations to February, make this easier. easier, because this is how I was doing it. It's easier in order to go through these in concert with each other if I have Exhibit A, your complaint and charges, out at the same time. And so, let us first look at, we're looking at, I guess it's subsection, in fact, subsection A, page 8 of 24 of your document, sir, as well as the synopsis number 1, as outlined by the Attorney General's office. And so this is, with regards to the auditor, in February 2019 special election, Auditor Perkins violated federal and state election laws relating to military and overseas voters, ballot boxes, provisional ballots, and the canvassing board oath and manual. And based on the information that was provided on page 8 of Mr. Hart's document, it has 4 different paragraphs going through this and detailing information, and also references us to go and look at exhibit number 1, which is the August 2019 SOS Skagit County Election Procedures Review, the 2019 special election. So I will take judicial notice of this document. It appears that it was filed with the Office of the Secretary of State. It was filed, it was the first report issued in August of 2019. And it talks about on page 3 of it that the reviewer observed election practices during the 2019 February special election. On the very next page, it gives the date of that special election, which was February 12th, 2019. And so this is detailing information. I did take note that that the facts in that this person was supposed to be observing is based upon observations of an election that Ms. Perkins didn't have any involvement with. She was formally elected just a few weeks before the election actually took place. And nor does it actually mention Ms. Perkins anywhere within the document, nor does it list any specific acts that she allegedly committed that were supposedly unlawful. I believe what the proponent was trying to suggest is that the suggestions for improvement that are outlined beginning on page 6 of this document, it starts talking about the suggestions for improvement. They are not indicating that any unlawful act has occurred. It specifically says underneath the heading suggestions for improvement, these suggestions assist the county elections department in implementing state and federal laws and rules. They are attempting to help each of the counties when they do these reviews to improve their systems. They are not indicating anywhere within it that some act was done unlawfully, or that some criminal act was done, or that someone intended to commit an unlawful act. But most importantly, it doesn't indicate any specific dates as to when an unlawful act might have occurred, or any facts that support an inference that these alleged acts involved Ms. Perkins. And so at this point, this particular charge, with regards to synopsis number 1, is deemed factually and legally insufficient by the courts. We turn to synopsis number 2. You are standing, sir?
Are we going to go through and provide clarification on what you're commenting about? Or
No,
is this-
that was the point of giving you the oral argument in order to provide any additional information to me. Now I'm simply going through and giving my ruling as to my review of the documents and the listening to the information that was provided with oral argument.
I asked specifically before if I would be able to go through the point by point. You said, yes, next. Is that not what this is?
Well, I gave you the opportunity in order to speak with regards to each of these synopses. You indicated that after you had asked whether or not you were going to be given the opportunity, you then indicated that you've laid it out in your documents and your pleadings. And then you got the second opportunity in order to speak. And so now we're to the point of the ruling. Was there additional information that you had wanted to address with the court?
Well, yes, on the courts or judge, your statements there's information that in your statements I can tell you're not aware of that's in front of you.
I read through these documents 3 different times yesterday, sir. So if it's in the documents, then I reviewed them. And when you lay out your charges, as it indicates within the statute, you are to lay out the charges in detail, and they're to be typewritten. And so you have laid out the charges as you deemed fit. That's pursuant to RCW 29A 56.110. And so, and that's why I asked you if there was any additional information that you wanted to provide to the court outside of your pleadings. You indicated that there was not.
Well, I don't agree with that. I had thought that we were going to go point by point on the proposals, and you were going to make a judgment.
Well, I did go point by point by reviewing the pleadings and asking for additional oral argument if you wish to have any.
I do have point by point commentary on each of these.
Well, unless the commentary was written into your charges,
It's in my brief.
And in the brief, then I've already received that point by point, and now I'm addressing what my findings are.
Okay. Judge, I'm going to sit down and let you finish this out. I only had 2 points to make then, if I can.
Go ahead and make your 2 points.
First, am I incorrect that I am to state the acts of malfeasance, misfeasance, and violations of the oath of office that justify that I'm requesting public voting on the recall of these officials? Is that not the standard that we were going through?
That you're required in order to provide specific dates for these unlawful acts and identify what those unlawful acts are in specificity. And you have to have a nexus between what those acts are and the individual that you are laying the charge against. You also have to be able to prove, in order to prove sufficiency, provide proof to the court that they intended to act unlawfully.
And neglect of duty is an intentional act. And that is stated.
You still have to be able to prove the intent. And right now, I'm not finding, at least with regards to number 1, that there's any facts supporting any inference that an unlawful act occurred by Ms. Perkins. And nor does your document that I took judicial notice of indicate any specific information or facts that could be used in order to infer that Ms. Perkins was involved.
She was in office and ran the election. That is her duty under the law, to run that election that was in that report. And the RCWs are mentioned.
But you haven't identified an unlawful act. This document is simply providing suggestions for improvement in order to make sure that the elections go smoother over time. It specifically says that in the document.
And on page 8 that you referenced, I can count no less than 12 unlawful acts being noted to the court. Specific statutes referenced. Is that not?
You have the specific statutes that are referenced, sir. But none of the facts, you're simply citing statutes. You're not indicating that on a specific date that Ms. Perkins specifically was involved in that unlawful act.
It was for the entire election, as the findings of the Secretary of State has indicated. Are you saying that, for my own knowledge, are you asking that I would know the date of the violation, not just the election period that it occurred?
That would be correct.
Is that required for this?
Yes.
It is required, the date.
It would be required in the date, as well as what specific act it is that's being alleged and what specific act is being attributed to Ms. Perkins.
So even though I say, and I want to make sure I understand what your judgment is I can say the February of 2019 and give you the 12, 13, 18 RCW violations, but
But there's no indication that Ms. Perkins is involved with any of those violations or that those were actual violations. These are simply suggestions for improvement. They're not indicating that whoever it was that was responsible for these acts, that they were unlawful.
so would a
Nor does it indicate anywhere within it that anybody that was performing these acts, whether or not it be Ms. Perkins or the previous auditor or anybody involved with the election process, was acting intentionally to do that unlawful act.
So what we're doing today is we're determining the truthfulness of the allegations.
No, we're not determining the truthfulness of the
It
allegations.
sounds like we're determining the truthfulness of the
Well,
allegations.
then you are mishearing me, sir, because that is not what it isn't here for, and I already told you what the court is here in order to determine and what that rule of law is.
It's not the truthfulness we're doing right now then.
Right.
And we, even though I have, and the document indicates the statute violations in it in the footnotes, which I didn't hear you mention.
And I've already addressed that and indicated that that is the case.
Okay.
So,
And then it has February, and then even though she was the one with the responsibility and duty under the Constitution and her job requirements as the auditor, the hole in that you're seeing from how this was presented.
you're making a conclusory argument, sir, without actually pointing out any of the facts in order to support that conclusory argument. And that is not sufficient based on the case law. We're not going to keep going through this, sir, okay? So I've made my ruling on synopsis number 1. We're going to go ahead and go through the rest of it and make the rulings on the others, okay?
Okay. Judge, I had forgotten to ask, because I did go to the auditor's office before this started. You have an oath of office on file with the Skagit County auditor right now?
Have a seat, sir.
I'm going to ask you
Sir,
again,
have a
Judge.
seat.
I'm going to ask, do you have an oath of office?
I am a
as-
visiting judge, and I have just ordered you to have a seat. So have a seat, because I am giving my ruling now, and
Judge, do you have an oath of office with the Skagit County auditor for the position you're in right now? That's 3 times I've asked you.
have a seat, sir. That's
I-
3 times that I've told you. If you would like to be found in contempt, then I can certainly do so. I gave you the extra moment in order to ask your additional question. And now you're making informal allegations against me simply because I'm providing you with my ruling and providing you with the case law. That is inappropriate, sir.
Judge, you are...
I am a
acting
visiting
very-
judge because you have recused and affidavitted everybody else.
I have only recused one judge. Only one.
Sir, may I continue with my ruling?
Not if you don't have an oath of office with the auditor. I believe this hearing is in violation of the law unless you can provide me
Okay,
an
well
oath
then
of
that's
office.
something that you can bring up in another matter. Today, we're continuing with the hearing on the petition. Are you leaving at this time, sir?
Judge, if you do not have an oath of office on file that you can provide me...
I do not
am leaving
require to
this
have an
hearing.
oath of office in order to be a visiting judge, sir.
Judge, this is an illegal hearing.
No, it is
and
not,
in
sir.
violation of law.
Are you leaving this hearing at this time? All right.